scheme is now in session.
I'll take the appearances. Mr. Gregory?
Commissioner, I appear today with Mr. Scott, Ms. Berry and Ms. Marsh.
And Ms. Hogan-Doran?
Commissioner, I appear on behalf of the Commonwealth.
Ms. Hogan-Doran, the directions hearing is to do with responses to notices to produce and notices to give. But there's another matter that I think might conveniently be dealt with at the start, and that's the question of leave to appear for certain people and the Commonwealth itself. Seems to me it would be simplest if I just advised you now that I grant leave to appear to the Commonwealth throughout the Commission, and I grant leave to appear to those persons who were ministers of the Department of Social Security and Human Services, I think Social Services and Human Services, those people who were secretaries of the department, and I think there was a CEO of Services Australia. For the period between the beginning of 2015 and the settlement of the class action, which was November 2020, that's purely on the basis that there's a level of responsibility there that would convince me that we had an interest. It's not to say, of course, that anybody must appear or that we're not looking at other people and other periods. But they're simply the ones that it seems to me it would be expeditious just to say that immediately that they have that leave.
Yes, Commissioner.
Thank you. And now we'll turn to the subject matter of the directions hearing. Mr. Gregory?
Yes, thank you, Commissioner. The topic of the directions hearing today is the delay on the part of the Commonwealth in producing information and documents in accordance with the notices issued by the Commission. I will shortly tender a letter with 5 annexures and attachments which identifies the matters outstanding as at 4 p.m. yesterday. Before I tender those documents and address their content, I will provide some context. And I note that the Commonwealth was informed that a copy of the letter and attachments would be provided to you, Commissioner, in advance of the directions hearing this morning, and I confirm that has occurred. This commission was announced by the Prime Minister on the 25th of August 2022 with a date to report of 18 April 2023. The matters of the inquiry are set out in the letters patent, and they make it plain that the persons in a position to provide evidence will largely be drawn from those who were in the executive or legislative branches of government when the scheme was established, implemented and ultimately discontinued. As I said at the initial hearing, much has to be done to prepare for the first public hearing, and the appointment of the Commission reflects contentions which have existed for a considerable time. The material sought by the notices will not be a surprise despite its volume, and the turnaround time for production of material in response to the notices for the first hearing will be short. Indeed, there is a degree of overlap between the issues identified in the letters patent and the subject of inquiries in early 2017, although the terms of reference are broader in some respects. The troubled history of the scheme ought to have made it more likely that documents prepared in response to questions raised about its various stages are more easily produced. The terms of the letters patent raised questions of legal professional privilege and public interest immunity claims, which had to be determined quickly. But of course, all of that is said with the acknowledgement that time is limited and the issues are complex. The Commonwealth requested notices to produce all documents in its possession, including documents prepared and disclosed in the class action proceedings in the Federal Court. It, of course, is entitled to adopt that position, but the obvious consequence is that in order to fulfil its task of the Commissioner, or rather your task, the Commissioner should err on the side of drafting notices more broadly rather than more narrowly, because the opportunity to consider readily available documents with a view to narrowing the scope of the notices for the first hearing was lost. However, I can indicate care was taken to ensure that notices were issued which would minimise the burden on the recipient. The majority of notices to produce material for the first hearing, which of course commences on 31 October, are directed to the government departments responsible for the implementation of the scheme and particular persons within those departments. All notices reflect the subjects of the letters patent, and solicitors assisting the Commission adopted a process of sending draft notices to the solicitors for the Commonwealth and inviting feedback in consultation with the proposed recipient of those notices before they were issued in final form. That opportunity to comment was not limited to feedback, but included feedback about the scope of the notices and the volume of material which might be produced in response. On a number of occasions, feedback was not provided. On a number of occasions, a complete response to the final notice was not produced by the due date, and that included occasions where the inability to produce material on time was not foreshadowed. On a number of occasions, requests for extension of time were sought by the Commonwealth, and on most of those, and to the greatest extent possible, those extensions were granted by the Commission. I say that these are not matters of inconsequential procedural irregularity, although some of them may be, for three reasons. First, Section 3 of the Royal Commissions Act provides a person who fails to produce a thing required by a notice commits an offence punishable by imprisonment for up to 2 years. Notices should be understood in that light. Secondly, delays in production of documents directly impairs the ability of those assisting the Commission to prepare for the first hearing. For three reasons: the volume of the material produced so far, more than 120,000 documents, with a further 100,000 foreshadowed late yesterday, the compressed time frame of a little over 2 weeks to the first hearing, and the need to consider the material before issuing notices to witnesses to appear at the first hearing. It is of some concern that the volume of material disclosed and foreshadowed to be disclosed may reflect an inadequate screening process to ascertain what is truly responsive to the notices. But of course, those assisting the Commission are not in a position to say one way or the other about that, apart from identified duplications of documents and some obviously irrelevant ones. The third reason why this is not a matter of inconsequential procedural irregularity is the flow-on effect. The second public hearing will commence on 5 December for a period of 2 weeks. Notices to produce material for the second hearing are currently being drafted, and some have been sent in draft form. The due date for those notices will not be later than the last day of the first public hearing, so that those assisting the Commission will be in a position to use the 3 weeks available between the first and second hearing to fully prepare. Commissioner, I tender the letter from the solicitors assisting the Commission to the solicitors for the Commonwealth, dated 12 October 2022, with attachments. I understand that exhibits tendered in the elections hearing today will be uploaded to the Commission's website in due course.
Yes, that'll be marked as the first exhibit in the Commission's hearings. The actual marking hasn't yet been decided, but it will be effectively exhibit number 1.
Commissioner, because you have had a copy in advance, I don't propose to go through the document in great detail, but I should note at the outset that if I can take the Commission to Schedule A, which is the notice to give issued to the Commonwealth of Australia, and page 3 of that notice, there is a reference to a NTG 0014, a notice to give a statement and produce information issued to Services Australia. I inform the Commission that a response has been provided to that notice since 4 p.m. yesterday, and its inclusion is now a matter of history rather than present concern. Otherwise, Schedule A and B and the 3 letters which are annexures to the letter set out what is currently outstanding, and those schedules generally speak for themselves. That short table, or those two short tables, provided for clarification on the record about the history of what was the position as at yesterday afternoon. And accordingly, I seek the assurance of the Commonwealth in three respects. Firstly, that the material outstanding will be provided forthwith. Secondly, that the
Slow down a little, Mr. Gregory.
Sorry, Commissioner.
Okay, material outstanding to be provided forthwith.
Secondly, the materials sought in notices which are current, and a number of those fall to be delivered up towards the end of next week, will be produced on time. And thirdly, that early indication be given by the Commonwealth of the specific circumstances in where the timeframes cannot be met. Of course, those assisting the Commission will continue to accommodate requests which fall into that third category to the greatest extent possible. Before I complete what I have to say, I can indicate I have said what I need to in respect of the main topic, but this is an opportunity to observe on an unrelated topic that the Commission has received submissions through the website from a range of people who were affected by the scheme in one way or another, or involved with it, and those who have offered constructive insights into it. And those submissions are most welcome and welcome on a continuing basis. Thank you, Commissioner.
Thank you. Ms. Hogan-Doran.
Commissioner, I seek to address you with reference to two letters that have been sent to the Commission to those solicitors assisting. Could I just identify those two letters which have been sent this morning?
I think I'm being provided with something. Thank you.
Thank you, Commissioner. The first letter is a letter which is headed Royal Commission into the Robodebt Scheme Commonwealth Response, which I'm instructed was sent to the solicitors assisting at 10:22 a.m. Canberra time, which would be 9:22 a.m. Brisbane time. Commissioner, do you have that letter?
Yes, I do.
Thank you, Commissioner. I also propose to address you by reference to a second letter, which I'm instructed was sent to you at, sent to solicitors assisting at 9:55 a.m. Brisbane time, which is 10:55 a.m. Canberra time, which is headed Royal Commission into the Robodebt Scheme Commonwealth Response Legal Professional Privilege. Commissioner, do you have a copy of that second letter?
And shall I mark them as exhibits? Or
Yes,
have
Commissioner.
direct may be marked as exhibits? They can have separate exhibit numbers. Yes, thank you.
Commissioner.
In terms of time, they'll effectively be 2 and 3, but what the ultimate number is, it may be more complex than that.
Thank you, Commissioner. I'll refer to them in that way if it is convenient to you.
Yes.
Commissioner, might I just note before I do that, I wish to note that the assurances that have been sought by Council assisting this morning, I will seek instructions with respect to them. They were not the subject of earlier correspondence.
All right. How long will it take you? Do you want a moment now? Or?
Those assisting me will have heard what I've just said. I haven't had an opportunity even to say to them, please seek instructions. Okay. But perhaps if I could commence by addressing by reference to the correspondence that has been sent with a view to identifying a pragmatic and efficient solution to the outstanding production Commissioner, the Commonwealth is acutely aware that it is the central repository of evidence that is relevant to the work of your commission. The Commonwealth is working to respond to the notices the Commission has issued in a timely way, and that is in as timely a way as the circumstances permit. Those circumstances include, but are not limited to, the following matters. The first is consideration by the Commonwealth of the complex issues that arise in relation to its reliance on public interest immunity and legal professional privilege in the context of the Commission's terms of reference. I will shortly take your Commissioner to you with respect to correspondence as to legal professional privilege, and address you separately with respect to the position on public interest immunity. The second matter is the coordination of searches to be made by the Commonwealth across its various agencies and departments for material that is responsive to the notices that have been issued by the Commission to date, which I understand is something in the order of 23. Thirdly, the coordination of the production of that material to the Commission in a manner that will assist the Commission in its work, including both first and second review, or I think as Council Assisting referred or described it as a screening process. And the fourth is the coordination of a consistent application across agencies, including the departments, to the approach determined by the Commonwealth to be taken to public interest immunity and legal professional privilege claims. Commissioner, we would ask that you take into account that the Commonwealth is, of course, experienced in dealing with the requirement to produce large volumes of material to courts, tribunals, royal commissions, and, of course, inquiries. And we ask that the Commission, and submit that this Commission should evaluate the Commonwealth's genuine attempts to comply with the Commission's notices against that background. Commissioner, there has been an opportunity to comment on draft notices, and there has been active work between those assisting you and those instructing me. And the Commission, of course, knows the number of notices that it has issued, but we appreciate that it does not yet have visibility of the scope of the material that is caught by the notices as issued. In the time that the Commonwealth has had to establish for itself the scope and nature of the exercise it must undertake to comply with the Commission's notices, it has become readily apparent that the scope of the notices is significantly broader than the Commonwealth initially anticipated. The letter, which I won't take you on withdraw that, Commissioner, I won't take you through, but the letter then sets out at the second page instances or examples by references to the notices to produce addressed to the agency Services Australia and notices addressed to the Department of Social Services, which are respectively recipients of notices to both produce and to give a written statement. One particular aspect of notices issued to both Services Australia and Social Services is identification of documents and provision of a table as to an extremely broad category, namely all decisions made in respect of the Robodebt scheme, as that is described in the letter's patent. Commissioner, is it convenient that I then address the second letter, which, Commissioner, you've marked as, or indicated would be marked as Exhibit 3? I appreciate that those instructing you, those assisting you may not have had an opportunity to review this letter given the time at which it was provided to solicitors assisting.
Can I just take up a couple of things with you first, Ms. Hogan-Doran?
Yes, Commissioner.
As I recall, the election was in May this year. So from then, it was really government policy that there would be a commission of inquiry into the Robodebt scheme. So that can't have come as any surprise to Services Australia. And it also can't have come as any surprise that as a commission of inquiry into that scheme, the net would be flung wider than it was in the Ombudsman's inquiries and the Senate's inquiry. So that there was rather a lot of time to be thinking about topics as broad as decisions made in respect of the Robodebt scheme. It must have been fairly obvious that that kind of category of document would be the subject of notices. And having said that and inviting your response, can I say, I obviously take into account the amount of work this is imposing on those instructing you, and I very much appreciate your cooperation, their cooperation with the solicitors assisting the Commission. The problem is we're all on a very tight line here, and it does seem that deadlines are not being met and warnings not always being given that that would be the case. It seems that 10 o'clock sometimes turns to 3 o'clock. And that really isn't satisfactory. So I don't know if you want to deal with that now, or you'd prefer to go on to the second letter.
Commissioner, those that instruct me, and from my own observation, if I may say, have been making genuine attempts to comply. There is, of course, a recognition of the circumstances in which the Commission's letters patent were issued, and the timeline that the Commission has set for itself to conduct public hearings and to prepare the report. The scope of the notices has, in giving effect to the searches, review and production, has been compounded by the broadness and being broader than was anticipated. Now, one substantial aspect of production has been identifying the way in which the Commonwealth would provide to the Commission documents which would be otherwise the subject of legal professional privilege. The production of documents of that nature, it is appreciated and understood, are raised squarely by at least two aspects of your terms of reference. And there are earnest steps being taken to propose a way in which that material can be provided expeditiously to the Commission, and indeed key advices have been provided already.
Surely that's not a huge area of discovery though, is it? I shouldn't have thought there were hundreds of advices. I certainly hope not.
The terms of the notices do not seek only production of the advices, but seek descriptions concerning the advices and, for example, actions taken in response to a particular advice, communications concerning or relating to an advice. So it is the matrix of what emerges from it.
Yes, even so, you'd think that the focal advices must be limited in number so that the number of documents surrounding in that respect can't be huge, but I understand what you're saying.
Yes. Commissioner, would it be of assistance if I identify the matter set out in the second letter?
Yes.
In that context? Thank you, Commissioner. Commissioner, the letter is not before you, but it was communicated to,
I'm sorry, which letter are we talking about? I've got one dated 13 October. Is that the?
yes, Commissioner, in paragraph 2 of that letter, reference is made to a letter sent on the 7th of October 2022. That is the letter to which I am making reference.
All right.
But it is summarised adequately in that paragraph for current purposes. That is that on the 7th of October, the Australian Government solicitor advised that the Commonwealth intended to waive legal professional privilege in relation to certain documents, and that it needed to give effect to that decision with respect to the production of documents to the Commission and the provision of statements of information to the Commission. As I said earlier, Commissioner, the reason for that decision, that is to advise you that the Commonwealth intended to waive legal professional privilege in relation to certain documents, was that the Commission, it is accepted, will need access to legal advice to be able to fulfil its terms of reference. Specifically, the terms of reference which focus squarely on legal advice and legal challenges in relation to the Robodebt scheme, in particular paragraph G of your letters patent, being the establishment, design and implementation of the Robodebt scheme, including, as is set out at Roman 4, any concerns raised regarding the legality or fairness of the Robodebt scheme. And then terms of reference I, being in relation to concerns raised about the Robodebt scheme following its implementation, and Roman 5, how the Australian Government responded to legal challenges or threatened legal challenges. Commissioner, this letter, paragraph 4, by way of assistance to you, Commissioner, as to giving effect to the Commonwealth's decision to waive legal professional privilege with respect to certain communications, the Commonwealth considers that the advices relating to the legality of the Robodebt scheme created up to the date of 27 November 2019 are likely to be the most directly relevant to the letters patent. That's because that is the date the Federal Court of Australia declared, with the consent of the Australian Government, that a demand for payment of an alleged debt under the Robodebt scheme was not validly made. Accordingly, the Commonwealth will waive privilege in relation to those advices. Just pausing there, Commissioner, if I may, I think it's set out in the schedules that Council Assisting has provided, and is now set out again in paragraph 5 of this letter. The Commonwealth has already provided a collection of legal advices of this kind, including the advice of the Solicitor General, in the hope that that will assist the Commission and those assisting you, their preparation for the 31 October 22 hearing. Those were 10 legal advices that relate to the notice to give a statement of information, number 1, issued to Services Australia and on the 11th of October, and 17 legal advices that relate to the notice to give a statement of information, number 2, issued to the Department of Social Services, and those 17 legal advices were provided on the 7th of October. Commissioner, I confirm that the Commonwealth waives legal professional privilege in relation to those advices and understands that the Commission will tender, use and disclose those advices as it sees fit. Commissioner, you have already identified that there are a key number of legal advices and a quantum of legal advices that can be identified by number. But as I have indicated to you, there are a range of ways in which those advices have been sought by those assisting you to be addressed in the production of documents and in statements of information. What the balance of the letter from paragraph 8 sets out is how the Commonwealth proposes that other legal advices that the Commonwealth would likely waive legal professional privilege over, but which have not yet been produced to the Commission, will be managed. And that is with respect to what is, with respect, a large volume of material that is involved. The issue that is addressed in paragraph 9 is an appreciation that there may be communications which of a legally privileged nature, which may not be directly relevant to the terms of reference in the letters patent.
And sorry,
And the Commonwealth would wish.
I'm sorry, Ms. Hogan-Doran, I just want to make sure we're looking at the same thing. Did you just say paragraph 9 dealt with this issue?
Yes.
My paragraph 9 is the Commonwealth is conscious of the need for a pragmatic and efficient solution. This is the 13th of October letter. I'm looking at the right thing.
Commissioner, may I just pause for a moment? It would appear that the document, could I just take some further instructions in relation to the document that you hold and the document that I hold?
All right. You may have an older version, or I may. We'll find out, I guess.
Thank you, Commissioner. Just one moment, if I may. Commissioner, could I just indicate that a copy of the document that you have is being sought and will be provided to me shortly? The document I have is not the document that you have.
No, well, that seems evident. Mine has altogether 12 paragraphs, so I don't know if I'm missing something critical. But Ms. Hogan-Doran, I see that what you're proposing is a way of producing the balance of legal records, but maintaining privilege, handing them over, but saying, we're not giving away privilege, you have to tell us before you want to use it. That's something I thought you might have sorted out with the solicitors assisting the Commission and Council. It doesn't really address the problems we're about to hear about today, does it? Which is that delivery so far has been late, not when indicated, not always with an explanation of delay. I mean, this sort of thing may well be able to be sorted out. I don't know that we're really meaning to have a directions hearing about this, though. How are you getting on with the instructions for the 3 things Mr. Gregory asked for? I think what we really want to do today is make it clear that we need things when they're asked for, or on an extension where that's explained and granted, that they have to turn up at the time appointed, that it's no good just letting things drag so it's the next day or much later the same day. And what is really wanted from the Commonwealth is an assurance that everything that's outstanding will now be provided, and that this slightly ramshackle means of provision won't continue. And I'm sure it's the cry of every Royal Commission, Ms Hogan-Dora, and I'm sure these problems arise every time.
Yes,
Sorry, you
Commissioner. Yes, and I accept that, Commissioner, and I have experience of other Royal Commissions, and those that are instructing me and those who are working across the Commonwealth are conscious of the needs of this commission and are making genuine attempts, and substantial resources have been deployed and are being deployed, given that the Commonwealth is the central repository of the material that will be necessary for your work.
Well, are you in a position yet to assure me that the outstanding material will be provided straight away, as in 5 p.m. today?
No, Commissioner.
And presumably the other two matters, which are that the current notices will be met on time, and that there be an early indication of why and how it is that a time can't be met, so something else can be arranged if it's essential.
Commissioner, I'll seek some further. I'll just have those instructions confirmed. In paragraph 1, the first assurance that was sought was that material would be provided forthwith. The communications that have previously been made to the Commission would be that material other than which is the subject of legal professional privilege and public interest immunity were foreshadowed to be provided by the end of this week, which is tomorrow, as opposed to today. And what is said with respect to the practical approach, which I accept is something that could be communicated further between those instructing me and there's those assisting you, but has been brought, because of the directions hearing, brought directly to the directions hearing for consideration, would mean that if that position is accepted with respect to legal professional privilege, the instructions are that I have is that that material will be able to be transferred from the Commission's providers within a matter of hours. As to communications concerning current notices and those that will be due at the end of next week, the Commonwealth has heard what has been said as to the utility of there being greater communication between the Commission between the Commonwealth and the Commission, so that if deadlines are unable to be met, there are specific circumstances identified as to why that is, and proposals made so that an appropriate extension of time can be given. The third assurance that was sought was that an early indication be given as to those specific circumstances. That has been the endeavour, on my own observation, that has been the endeavour to date, and there's no reason why that wouldn't be the position going forward.
Right. Ms Hogan-Dora, would it be helpful if we went back to Mr Gregory now so that he can respond to that, but also to the proposal that the legal professional privilege material be handed over with the caveat that you've identified? So I can hear what he has to say about it. And are you happy if that happens?
If that's convenient to you, Commissioner.
All right. Thank you. Mr Gregory, do you want to respond?
Yes, I can confirm to my learned friend the proposal in paragraph 10 of the letter that I have is acceptable to the solicitors assisting the Commission. The second point is in respect of the assurance that outstanding matters are hoped or intended or foreshadowed to be provided by the end of this week. Those assurances in similarly broad terms have been made previously, and not always delivered upon. And we're now not much more than 2 weeks away from the start of the commission. So something more concrete is sought from the commission. There remains the outstanding question of the determination of public interest immunity, and it was under consideration a week ago. At least it was communicated to us that it was under consideration a week ago. We're not sure when a decision will be made on that and whether any information can be provided about it. And a note of not particularly great significance is that the second exhibit, the letter of 12 October 2022, the commission was taken to paragraph 9, which described a request for decisions made in respect of the Robodebt scheme as extremely broad. The notice NTG 0001, of course, limited decisions to those made by ministers and members of the senior executive service, so not as broad as it might have been conveyed. But those are the matters that I can respond to immediately.
All right. Coming back to you, Ms. Hogan-Doran, do we have an assurance that the outstanding material will be provided by close of business tomorrow? And do we have an assurance? Sorry, did you get that? Do we have an assurance that the outstanding material will be provided by close of business tomorrow? Close of business in most normal circumstances, meaning 5 p.m, but you get an hour's daylight saving grace here.
Commissioner, with respect to the legal professional privilege material, which is a substantial amount of material, on the basis that is set out in the correspondence, that can be done and give you the assurance that that will be provided on that basis. With respect to public interest immunity claims, the documents that are the subject of such claims, Mr. Gregory is correct in saying that it was under consideration. It is under consideration at the highest level, urgent consideration at the highest level, but I'm not in a position yet to be able to communicate an assurance as to production with respect to that issue. With respect to the other documents, in respect of the other categories, I can only give you assurance as to some, but not all, for production by tomorrow afternoon at 5 p.m. Brisbane time.
Why is that?
There's a number of reasons. Those include in part just the simple mechanics of completing the reviews and the volume of the documentation that are the subject of those reviews.
All right. Look, I don't know that we can do much better than say that those instructing you should certainly aim to have that material produced by 5 p.m. and to have communication with the solicitors for the commission much earlier if in fact there is going to be any delay. And I wouldn't imagine that much more delay can be afforded on this material at all. And so if we're talking delay, maybe by tomorrow morning, by Saturday morning at the worst, but it has to happen. These, sliding deadlines just can't continue. In relation to the legal professional privilege material, you had spoken of it being available within hours. That doesn't have to wait till 5 p.m. tomorrow, presumably.
Commissioner, the provision is the materials are with our document management provider. So provided following a quality check, that material would be able to be transferred to the commission's provider within a matter of hours. That is what I have been instructed. There will be a number of steps just before that, that is identifying what that material is. It will be, in a global sense, communicating to the provider and that being given effect to. So it may not be by 5 p.m. today, but it's certainly within the scope of the assurance you sought for tomorrow afternoon.
Yes, I was thinking about other documents when I asked for that assurance. It doesn't seem that we've got an awful lot further here. Mr. Gregory, do you have any suggestions?
No, I appreciate, other than to observe that Ms. Oakendoran is, of course, limited by her instructions. But to the extent that they've been elicited in this hearing, they are consistent with the sliding nature of communications and respective deadlines so far. The reference to a number of hours appears at paragraph 12 of Exhibit 3 in my copy, which didn't appear to have the caveats on the time frame that were just identified by my learned friend.
Commissioner, could I indicate I have the same letter as you now?
Okay, which one came first? Is yours more current, or which one should we have?
The one you have is the one that is 12 paragraphs long.
I think that's right, yeah.
Yes.
Is it missing something vital that you had in your copy?
No, Commissioner, it's just, I think it's just the numbering.
All right, we'll settle for what we. Look, I don't want to waste any more time here. I do expect that your solicitors will make every endeavour to have that material here by 5 p.m. tomorrow. I don't want to be occupying the weeks between now and the hearing with a series of directions hearings that become increasingly demanding and mandatory in direction, as you'll appreciate.
Yes, Commissioner.
So if all that could be borne in mind, I think that we will, unless Mr. Gregory, you've got anything else?
No, Commissioner.
Leave matters there. Is there anything, Ms. Hogendoren? I don't want to cut you off.
No, Commissioner.
All right. Thank you for your time. It's nice to see you in the flesh. We'll be seeing, oh, sorry, not in the flesh.
No.
In your face at least, and we'll be seeing a good deal more of you in the coming months, I gather.
Indeed, Commissioner.
Thank you. We'll end the connection there. Thanks.
The Royal Commission into the Robodebt scheme is adjourned until Monday, the 31st of October at 10 a.m.